Welcome to today's Explainer. I'm super excited to have you here because we're tackling something that is honestly one of the most fascinating and practically useful areas of the law. Right now, we're setting the stage for a deep dive into the principal-agent relationship. Specifically, we're looking at who actually pays up when things go horribly wrong on the job. So we're going to review vicarious liability and figure out exactly what it means to be an agent in the eyes of the law.
Okay, picture this relatable hypothetical for a second. Let's say you hire a company to do some work on your house, right? And one of their workers accidentally drives a massive truck straight through your pristine, newly painted front fence. Just a total disaster. The question immediately becomes, can you sue the boss for what the worker did? As you'll see, introducing the practical reality of tort law means acknowledging that, well, injured plaintiffs usually want to sue the entity with the most money, not just the individual guy who made the mistake.
Okay, let's dive right into the exact checklist judges use to sort through these messy situations. First, we'll look at the deep pockets dilemma. Next, what is vicarious liability? Then, employee versus independent contractor. After that, the scope of employment, followed by frolics and minor detours, and finally, we'll wrap up by looking beyond employers to legal partnerships. Starting with Section 1, the deep pockets dilemma, shifting the burden of risk. Before we throw a bunch of heavy legal terminology at you, we really have to understand the core problem the law is trying to solve here. Think about it. There's an inherent unfairness in our system if an injured person can't recover damages just because the specific worker who caused the accident happens to be completely broke. The reality is, lawsuits are incredibly expensive. Winning a judgment against someone with empty pockets, that's just an empty victory. So plaintiffs, totally understandably, seek out the deep pockets. We're talking the businesses, the employers, the corporations, to ensure actual recovery for their damages. This incredibly pragmatic pursuit of compensation is literally the driving force behind all the legal doctrines we're about to explore today. It's all about making the injured party whole. Moving to Section 2, what is vicarious liability? The doctrine of Respondeat Superior. And that brings us directly to the core legal rule that actually solves this deep pockets dilemma. It's called Respondeat Superior, which is really just fancy Latin for let the master answer. By definition, it's a legal doctrine where an employer is held vicariously liable for the tortious acts of an employee committed within the scope of employment. Put simply, if the agent messes up while doing the principal's work, the principal is the one who pays the price. Now look at this highlighted excerpt from our legal text. It explicitly states that enacting safety procedures does not insulate employers from liability. Think about how massive that is for a second. Even if a boss takes literally every possible precaution, holds weekly safety meetings, and writes the absolute best safety manual in the world, they are still ultimately responsible for their employees' negligent actions on the job. No matter how hard you try, you just can't contract or train your way out of vicarious liability. But because this is such a heavy burden to drop on a business, the law definitely doesn't make it easy for the plaintiff. To win, a plaintiff has to pass a strict two-part checklist. Step 1, you absolutely must prove there was an actual employer-employee relationship. Step 2, you have to prove the act was committed within the scope of employment. If you fail to prove either of these, the employer is completely off the hook. Which takes us to Section 3, employee or independent contractor, the crucial first hurdle. We have to establish the exact legal status of the worker who caused the harm. Why? Because the law treats regular employees and independent contractors very differently when it comes to liability. To figure this out, courts look at what they call the extent of control. Basically, how much power does the boss have over the daily nitty-gritty details of the worker's life? Courts use specific factors to determine this right to control, like the nature of the work, the skill required for that occupation, and crucially, who exactly supplies the equipment or tools. Generally speaking, employers are not liable for the actions of independent contractors unless they step in and start dictating the minute details of how the work gets done. Let's look at a really specific hypothetical, pulled straight from the bar exam materials, to see how this control test actually plays out in the real world. Imagine a guy named Woody hires Chuck. Chuck is an independent, licensed contractor, and his job is simply to install a septic tank on Woody's property. But while doing this, Chuck accidentally trespasses onto the neighbor's land. So the big question, can the neighbor sue Woody for Chuck's mistake? Well, the answer depends entirely on control. Woody is only liable if Chuck acted under his express direction and wasn't free to act independently. If Chuck was just doing his own thing, using his own tools, and Woody just said, hey, put a septic tank over there, Woody is generally protected. Vicarious liability only attaches if the employer crosses that line into directly controlling the independent contractor's specific actions, because when they do that, they basically turn them into an employee in that moment.
Let's look at Section 4, the scope of employment. Was the agent actually doing their job? So the crucial point is, once you prove the worker is actually an employee, you move to the next hurdle. Were they actually doing their job when the accident went down? The law outlines 3 very specific criteria that must be met to prove an employee was acting on behalf of the business. First, the act has to happen within the employer's authorized time and space limits, meaning during work hours and on the actual job site. Second, the conduct must be performed at least in part to serve the employer. And third, the employee's actions have to be foreseeable to the employer. If the employee just goes completely rogue, the employer might actually dodge liability. Which brings us to Section 5, Frolics and minor detours, when things go off script. Okay, so what happens when an employee is technically on the clock, but they go a little bit off script? The law draws a pretty brilliant dividing line here. If an employee makes what's called a detour, which is just a minor deviation from their duties, the employer is still liable. But if the employee engages in a frolic, which is a major, substantial deviation or total abandonment of their work duties, the employer is not liable. Let's ground these abstract concepts in a practical, everyday scenario from our sources. We've got a business called Bob's Bakery, and they have a delivery driver named Doug. While out on his delivery route, Doug decides to completely abandon his assigned path. Instead of heading back to work like he's supposed to, he drives all the way across town to hang out at a friend's house. And while doing this, Doug negligently gets into a car accident with someone named Polly. So can Polly sue Bob's Bakery for the crush? Nope. Under the law, Doug's complete departure from his assigned duties is classified as a frolic. Because it was a major deviation strictly for his own personal reasons, Bob's Bakery is not vicariously liable for Doug's negligence during that specific time frame. That chain of Respondeat Superior, it was temporarily broken by Doug's decision to just abandon his job duties.
Finally, Section 6, Beyond Employers. Legal partnerships.
Up to this point, we've focused heavily on the whole boss and worker dynamic, but we really need to see how these exact same principles apply to liability among equals. Here is the black letter rule for partnerships. Partners in a professional firm are jointly and severally liable for the wrongful acts or omissions of any partner acting in the ordinary course of the business. What this shows us is that the agency concept creates this massive web of liability. In a partnership, you are essentially all agents of one another.
A perfect example of this is the legal malpractice case Murray v. Witherell. In this case, one partner in a law firm was actively misappropriating client funds. Naturally, the other partners tried to claim they were completely in the dark about the misconduct and shouldn't be held responsible. But the court said, no way. Because the bad-acting partner was using firm resources and acting under the firm's name within the scope of their shared business, liability was upheld for everyone. Claiming ignorance simply doesn't shield you when your partner commits fraud in the ordinary course of the partnership. Which leaves us with this final, lingering question to ponder as we wrap up this explainer. Is it truly fair to hold a business completely financially liable for an employee's totally unpredictable mistake, even when that business did everything right? Ultimately, the law has decided that, as a matter of public policy, shifting this massive burden of risk to the deep pockets who benefit from the labor is the best way to ensure injured victims aren't just left out in the cold. It's a huge burden for businesses to carry, for sure, but it's an absolutely crucial safety net for society. I hope this deep dive into vicarious liability and agency has sparked your curiosity about the invisible webs of legal responsibility that surround us every single day. Until next time, keep asking those hard questions.